case. Well, where did that law of the case come from? Well, in the absence of anybody decreeing it, the judge is going to fool around and kind of bring it in, because after all, there's so much ignorance out there, he can get away with it. Nobody objects. But the law of the case is decreed by the sovereign. You're the plaintiff, you decree what the law is. And the word is decree. Okay? You decree what the law is. And that becomes the law of the case. And I include a whole section in my lawsuits that is the law of the case. Okay, now let's go down here to I think it's the 14th Amendment. Here we are. In the 14th Amendment, it says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Of course, the excuse for having this 14th Amendment was so that the black slaves who had been freed could now have some standing, whereas there was no legitimate way for any slave to become a citizen of the state they were living in. The feds introduced this clause in order to, force the states to recognize that these black people who used to be slaves were now citizens of the United States. And if you're a citizen of the United States, you had to be recognized and you got all the benefits, privileges, whatever that you should get. That's the theory. Okay, well, actually this is a Trojan horse here, because they wanted to include everybody. Okay? They want everybody to be a citizen of the United States. But they couldn't change the Constitution to pull in the white folks. So what they did is they changed the educational system. Again, we go back to about 1850 when they created the first mandatory public school. But it wasn't until 1868 that we got the 14th Amendment. And the 14th Amendment defined, there's only one other place where a word is defined in the Constitution, and that's treason. Okay? And now here we have a phrase, citizen of the United States, and it's specifically defined. Not everybody can be a citizen of the United States. Or I should say, not everybody is a citizen of the United States. For example, its requirement is you have to be born or naturalized. Well, if you're born or naturalized, that's easy. Most of us are. But it also says subject to the jurisdiction. Well, what if you're born or naturalized and not subject to the jurisdiction? Well, then you're not a citizen of the United States. You still belong here, but you're not a citizen of the United States. Who are you? Well, I can tell you who I am. I'm one of the people of the United States. Okay? So, are you a 14th Amendment citizen, or are you a preamble people? Now, I do not accept the phrase sovereign citizen. Why? Because a sovereign is a master. A citizen is subject to the master. How can you be a master servant? That's why I reject the term. I never use it in my paperwork. In fact, I don't even say sovereign and I don't say citizen. I never use those terms. I stick with constitutional vocabulary. I say I'm a people. Let them challenge it if they dare. By the way, no one's ever challenged it. You know why? Probably because they don't understand the significance of it. They read through this, they go blah, 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 he's one of the people, I say, yeah, and they get down to the meat of it, right? Well, I'll tell you something. Being a people of the United States is what gives me the authority to bump off the judge. Get him, legally speaking, off the bench. He's still there, I let him play the part. I actually assist him in scamming the opposing attorney. Okay? You read the transcripts. That example case has also the transcripts. You can see how the judge reacted. Check out how the judge talked before he found out he was number 2. Okay? And then compare that to how he talked in the court after he got the order, vacating his order. Big change in attitude. And my method is educate the judge. Then when the judge wants to do something, he looks to me and he says, I think we should do such and such. And he says, is that okay? Or he just looks at me. And I say, yes, Your Honor, that sounds good. That's fine. What am I doing? He's not making the order. I'm authorizing him to make my order. Okay? Then he turns to the attorney, and you know all attorneys are taught in law school that the judge is an 800-pound gorilla. And if the gorilla demands a banana, what do you give him? You give him a banana. They're actually taught that in school. And so when he turns to the attorney and he says, is that all right with you? I have never, ever heard anyone say to the judge, no, Your Honor, you can't do that. Or I won't let you do that or anything, or object anyway. No, they say, yeah, okay. By the time you get to that point. But what's the difference? In the first case, the judge is asking for authority. In the second case, he's being polite and being soft with the guy. Because I'm the king of the court. Okay? Sovereign of the court. And all I have to do is say, I'm one of the people, and that covers it. Now, they don't necessarily understand what you're saying, so the very first time when I'm in court, all I do is if the judge does something, I say I object. He says, why do you object? I say, well, I really don't wish it that way. No, or I wish it to be some other way. Why do I say wish? Because when you're a king, my wish is his command. Okay, that's centuries of tradition backing me up. So it sounds like I'm talking softly, but I'm not. That's an order when I say I wish. The judge in his initial ignorance will say, well, if that's the best thing you do, you're overruled. Say, well, for the record, I do object. He says, all right, duly noted. You know. By the way, the word duly, what does that mean? I'll tell you because you don't know. Duly means, D-U-L-Y. That word means that whatever it is satisfies the requirements of both the common law and the statutory law. Whenever you use that word duly, that's what you're saying. So be careful how you use the word duly. Don't use it unless you mean it. Okay? That's more legal language. Words will trap you. Okay? If you say something is duly, that opens a way for them to enforce the statutory law against you. Okay? Their own law against you, if you decree it. Anyway, so then all of my court sessions last about 5 minutes. Hardly ever go beyond 5 minutes. Why? Because I don't handle business in court. All the business is defined in the paperwork. Any questions, it's in the paperwork. That's it. And if they do something, I object. And we go through that scenario. And then after we object, we leave the courtroom. That's when I sit down and type up the orders vacating the judge's decision, if he dared to make one. Okay? It's that efficient. This case that we have as an example, it's about 5 years old now. But don't let that fool you. It's 5 years old because we intended to produce a perfect case. We researched everything. And we let it stretch out so that we could do the job right. It's actually, the case should have been resolved in 60 days. There are a few delays introduced. We could have resolved those faster, but we wanted a perfect example. We got the bonus of finding the judge in contempt of court. We never expected to get to that level, but we did, so you got it. It's kind of fun. Okay, we fined him $1, by the way. He never paid it. Now, a lot of people tell me, that proves it didn't work. Well, let me tell you something. You run around giving orders, you better be right. Because those judges are not shy. They'll throw you in jail for contempt of court. It's a misdemeanor to put out a paper purporting to be a court order. You betcha. And what really happened was he got in trouble. I mean, he was in trouble. That was a good contempt finding. And the presiding judge pulled him off of our case and 900 other cases. We could have glued him to the case if we chose to, but we chose not to. What happened was that they assigned a new judge. They assigned him to another court in Timbuktu, different part of the county, handling only criminal cases. And the new judge, he seemed like an okay guy, but we looked up his background. We found out that this guy was their big cannon on our case. He and some other judges loved the common law. They had their own organization where that's all they do is study common law. They love it. He was a specialist in common law, and this case we had was a common law case. And on top of that, this guy, now this is a Superior Court case, this guy at one time was the presiding judge of the appellate department of the Superior Court in California. We had one of their sharpest men on the job here. But you know what? It made no difference. Why? Because he wasn't in charge. He couldn't make any decisions. You know, I like to tell people, partly because I'm mentally ill, I like to tell people that I am the world's foremost authority on how a guest should be treated and how a host should act when a guest is visiting a host in the host's home. Okay? You want to know anything about etiquette? Just ask me. I'm the self-appointed authority. I can tell you all about it. Okay? Now, there is one little detail. When I go to visit you in your home, how much authority do I have? Somewhere close to zero, right? That's the problem the judge had. He was in my home. You see? So, anyway, going back to this, citizen of the United States means that you're a 14th Amendment citizen and you are subject to the jurisdiction. People are not subject to the jurisdiction. Only citizens of the United States are subject to the jurisdiction. Okay? If you're not subject to the jurisdiction, you can't be a citizen of the United States. Now I got another one for you. In addition to all that, did you know that you can be a citizen of the United States for some purposes and not a citizen for other purposes, and the choice is yours? You decide. That's why I have a Social Security number. That's why I plan to get whatever retirement things they want to throw at me. That's fine. Because it's restricted to that specific contract. Okay? Unless there's some overt agreement on my part that I accept all those terms, and it better be knowingly, intelligently, you know, all those conditions for a good contract, they're in trouble if they try to carry it beyond the basics. So, you can be a citizen. Now, how is that possible? Well, here's what happened. Back in, well, we're in the wrong section here. We're in the people or citizen, which one are you section, okay? But let's go back to, well, sovereignty, okay? And so here we quote this case again. The people of the state, you know, it's king's prerogative and all that. All right. Now, here in the here in California, they have a section in the government code. Now, the government code is specifically written for them guys in government. Okay? The government code is not written for you or me, although it makes interesting reading sometimes, as I'm about to show you. But it's written for them. It's to tell them what the score is. These are their job instructions. Okay? So what does it say? Well, this is the beautiful one right here. You're going to love this. Okay? Where did it go? Here it is. Check this out. The people of this state do not yield their sovereignty to the agencies which serve them. Is there anything about that that you don't understand?
They don't understand.
Yes, they do. But you have to put it in terms that they understand. That means a court order. Okay? You're just going to walk up to any old policeman and say, hey, you know, you don't have any authority over me. He'll demonstrate how a gun works. Okay? So you got to use a little judgment here. But when you back it up, you'll see, when you go to read those court orders that are part of this CD, you'll see we lay down the logic. Okay? Starting with the preamble, working all the way through, and we bring this out too. The people of this state do not yield their sovereignty to the agencies which serve them. And I'll tell you something else. It's in there twice. See down here? Okay? section, also the government code.